Thank you very much. Good afternoon. I hope you are having a very good stay here in University of Coimbra. This is the oldest university in Portugal and perhaps in the world. And I'm glad to be invited to this lecture, to this conversation with you about history of human rights. I'm not belonging to this law school. I'm a full professor of law from Lisbon, the Nova University of Lisbon, but we are very good. We have a very good relationship between all the law faculties in Portugal, and I'm glad to participate and to be invited to this organization, and congratulate Pedro for this kind invitation for me. My topic is about history of human rights. Unfortunately, we don't have a very good place to project this PowerPoint slide, but I think you can see what kind of topics I will talk about. But in my view, I would like to have two main themes. The concept and the principles about human rights. We all talk and speak a lot about human rights, but perhaps there is the need to be more precise and to understand precisely what is the meaning of human rights. And a second issue about the evolution of human rights till now, from the very first beginning, that is the Universal Declaration of Human Rights, till nowadays. You can see in this PowerPoint, if you want to note it, my email address and my mobile phone also. So this is the two topics of my reflection for you: human rights and public international law, and secondly, the evolution of human rights, international law, treaties and systems. Obviously, we can ask some other points for me. No, put your questions. Do not be afraid of putting your questions. Usually the students in this law school are very afraid to put some questions to the teachers, but since I'm not belonging to this law school, you can put freely what kind of questions you want to put in order for me to give the information there is need, and so you can understand all the things I will going about to talk. So first, the human rights and public international law. Let me see if this thing is working more or less. I think we can see. The first idea is what is the main features of the history of public international law. I suppose you are law students, all of you, so I can be more technical in this kind of language. But you know, the public international law is not an old branch of law. Not like the civil law, because in Rome we had at that time a civil law, but public international law was founded after the Peace of Westphalia. That was a very important two treaties that put an end to a very important war between Protestants and Catholics in the center of Europe. Two treaties, the Treaty of Münster and the Treaty of Osnabrück. That was the famous Peace of Westphalia. And we generally considered that at that time the very beginning of the modern public international law. Till the end of the 19th century. It was a public international law without many things to say. It was a kind of a law to arbitrate litigation between states, but without any kind of restrictions to the national and domestic sovereignty of the states. So that is the first period of the evolution of public international law. But the most important period is the period when we live now. That is the second period, or we can say the contemporary period of the evolution of public international law that began in the beginning of the 20th century till now. Because in these 100 years, we saw many different things happening in the international community. Perhaps we can say that today the international community is completely different what we could see till the end of the 19th century. I can stress some features of that new evolution and this second period of public international law. The multilateralism and the international organizations. The most important organization were founded in the last century. Firstly, the League of Nations and nowadays the United Nations. The first one after the First World War, and the second one succeeding to that one after the Second World War. But generally, the idea of the states can cooperate between them, creating a new structure that is an international organization, a governmental international organization. Secondly, I can say the problems about international security and the prescription, the prohibition of use of force that was decided finally in the end of the Second World War, because the United Nations till now has the power to authorize all the wars we can see in the world. Nevertheless, in some occasions, there are local and regional conflicts that were not allowed by the Security Council of the United Nations. But the principle is that there is only one organ, only one body that can authorize the use of force in international community. That is the Security Council of the United Nations. We can also use the force as an exception, as a self-defense intervention, what is enshrined in the Article 51 of the United Nations Charter, but that is an exception because to have a lawful war or a conflict, or to be allowed using the weapons in the use of force to decide the war, there is the need to be authorized by the Security Council of the United Nations. Nowadays, we are facing new problems in this area because of the 9/11 and because of religious radical terrorism. And this is a new issue for the moment, where we can see different approaches, mostly related with the idea of legitimate defense and self-defense, preemptive defense and preventive defense. Also in the last century, we saw very important and new regulations about the air and the sea and the outer space, because were approved several important treaties about the law of the sea. That was the Montego Bay Convention, or about the outer space, mostly the first of one, the Treaty of Using the Outer Space, 1967. Another important issue that was after the Second World War, many colonies, mostly in Africa, could reach the independence, were allowed to be independent. In some cases with a civil war, or internal war, but mostly that was a peaceful process. Unfortunately, in Portugal, was a very complicated process, because we had a war between the Portuguese in Portugal, main Portugal, and those in the ex-colonies, the former colonies of Portugal. But after the Revolution of Carnations in 25 of April of 1974, that process could reach a happy end, giving to those former ex-colonies in Africa a legitimate independence, political independence. That is happened till today. You have independent countries: Angola, Mozambique, Cape Verde, Guinea-Bissau, São Tomé and Príncipe. And in Asia, or between Asia and Australia, East Timor is also, although more recently, independent from Portugal and mostly independent from Indonesia, that invaded East Timor after the Revolution of Carnations took place in Portugal. So this is, I think, these issues: multilateralism, the prohibition of use of force, new terms to use, international spaces, and decolonization, and the new countries that could reach the international community. Different things happen in this period. Now, talking specifically about human rights protection, that is my point, my specific point. As you can see, the human rights protection is not a very complicated issue. I think it's quite obvious. The idea of having protection of human rights, because what was the reason to create human rights? After the Second World War, we saw biggest genocide we could see in our common history, and countries thought very well and reached the conclusion that there was a need to change something in order to guarantee the protection of human rights. You can say, but human rights were created originally after the Second World War? No, because human rights are the same as fundamental rights. Or if you remember from your lessons of constitutional law, fundamental rights were created after the liberal revolutions, after the French and the American Revolution. After that time, all the constitutions, first the liberal constitutions, and after that the social state, welfare state constitutions, all those constitutional texts enshrine fundamental rights. But the point was that in many states, those fundamental rights were not recognized correctly, completely, or effectively. And so the international community concluded the need to have a new pattern, a superior pattern to defend, to protect human rights. But human rights is not the only way to protect persons and to protect the interests and the liberty or freedom of people, of citizens. Because we also have in international law, humanitarian law, that is not the same as human rights law. Is quite different, because humanitarian law is only can be only applied in a war situation, not in a peaceful or peace situation. You also have a new branch nowadays is important, very important, because of problems we have in the Mediterranean Sea. That is the law, international law related with refugees and the asylum rules. And obviously, you also have, that is the most, the first of the protection of people was the diplomatic protection that is normally conducted by the states protecting a foreign citizen that is in a foreign countries through the diplomatic representations that citizen can see in the foreign state. But obviously, within these four kinds of protection of personal values, the most important of them, the widely protection, is obviously the human rights protection. Now, something about the principles we can see dealing with this human rights international law. That is, as I said, a new chapter, a very important chapter of the public international law. And in some schools, law schools, we also have subjects only dedicated to this issue, or even a master in human rights law, or even a PhD programs only related with this field, with this subject. But we have some principles we can see dealing with this branch of public international law. There is the principle of the peaceful means to solve the controversy. That is a very important principle of public international law, side by side to the principle of the prohibition of use of force. If you are not allowed to use the force, obviously you have to solve the controversies, the disputes, through a peaceful mean. You also have a very important principle, that is the supremacy of human rights over all rules you have, either international law or in the domestic law. So human rights are so important that human rights can be qualified as jus cogens, that is the most high position of rules in the international law itself. You also have the principle of favor libertatis, that is in the case of doubt to understand the meaning of the rule or a principle, a written principle, we must reach the conclusion. If you are in doubt between two conclusions, you must choose the conclusion that can give more liberty to the individual, not obviously choosing the result that is restricting that kind of liberty or that kind of protection. Also, a very important principle is that all the rules dealing with human rights can be considered as a self-executing provisions or dispositions. That is a very important thing, because in many cases international treaties cannot be put in force because the states sometimes are not doing their jobs and refuse sometimes to legislate in order to put inside the domestic law the international treaties, but that cannot happen with human rights treaties, because usually we can consider those human rights treaties having self-executing provisions. Finally, a very important principle, not only a principle, it's not a specific principle of human rights law, this is a general principle of public law, international or domestic public law, that is the principle of proportionality. Is very important because if there is a need to restrict or to suspend the binding of some human rights law or disposition, you can do it only if it is allowed with the limits of this principle of proportionality, in order to save and to defend some other equal important values, in order to guarantee the constitutional order in case of state of exception, state of war, state of emergency, or in order to protect the rights of the other citizens. In that case, you can choose some measures, legislative measures, provisions to make the restriction in these human rights laws or provisions. Now, something about the importance of human rights. Perhaps is not is not idea to refer the importance of something that is obvious, that having human rights protection. But sometimes I wonder, and I have this kind of idea. 70 years ago, we didn't have any kind of human rights protection. So this is a very recent asset, a very recent good we have, only with 70 years. And as you know, our history is not doesn't have 70 years, but 2,000 or 3,000 of history. But human rights are very young. 70 years. We don't have 70 years, obviously, but I don't have 70 years. But human rights are really very young. 70 years is, yeah, indeed, in the we can consider human rights as a child. Children with 70 years is indeed the children through the history of public international law. But how important is the conclusion of having human rights? I think three aspects, three topics can justify that importance. Firstly, the certainty of having a formal recognition in a written treaty, avoiding the discussions, the philosophical discussions. Today, in the morning, you have a very big and interesting philosophical discussion indeed. But if you have the human rights written in the treaty, the international treaty, you don't have any doubt about the efficacy and mostly the existence of those human rights, because they are written. They are not created by God. They are not speculated by some important people or some politicians, because they are written. Surely with certainty in an international treaty, although the international treaty cannot vinculate all the countries in the world. This is a very important conclusion. The second one is the idea of these human rights, because in some cases constitutional revolutions could not bring a state, a rule of law in many countries. If you have human rights enshrined in the public international law, that means you have human rights and treaties above the domestic legislation, and those rights must be obeyed by the domestic legislation. So in that situation, you cannot have internal legislation that is not in conformity with the international law. So the international law is superior, has supremacy to domestic laws, and sometimes they are better than many constitutional laws, because in some countries we have dictatorships, we don't have good constitutions, and in some countries the fundamental rights you have in those constitutions are not complete, are not effective fundamental rights. So if you have in a higher place human rights, that is a guarantee for the efficacy and the effectiveness of those human rights. Thirdly, I would like to stress the importance of human rights in the perspective of these human rights can be equal for all people in the world. They are equal for all of people, in spite of the difference of culture, of religion, ethnical features, or anything else. We all have the same rights. We are all equal, and we are equal to access the same rights in the world, in spite of the differences we can see in our world. Nevertheless, perhaps now, because of globalization, those differences are not so deep as before, but I think the idea of having human rights is a very good idea, just to put together different regions, different cultures, and to consider the people, the person, with equality and all having the most important values you can imagine in the society, in a good society with the rule of law. From the beginning, that was in the Universal Declaration of Human Rights till now, we usually say that there are three different generations of human rights. The first generation is corresponding to the political and civil liberties in the 19th century. A second generation related with economic and social rights, and professor lectures usually nowadays are speaking about the third generation or fourth generation or even a fifth generation of human rights. Human rights related with privacy, with use of internet, with bioethics, the defense of minorities, and this kind of new issues, environmental issues, obviously. So those fundamental rights, those human rights, we can consider integrated in a third or in a fourth or even in a fifth generation of human rights. Some people speaks about the right to peace. So the right to peace nowadays is considered one of the most important human rights belonging to the fifth generation of human rights. Now, the second part of my intervention today about the evolution of human rights, international law, treaties and systems. Obviously, I'm not saying you anything new, but we can remember something you already study in your law schools. The very beginning was the Universal Declaration of Human Rights. This year is a very important year. Because of that, Elsa Coimbra obviously is commemorating this important Universal Declaration on human rights, because in this year of 2018 we have 70 years of the approval of this Human Rights Declaration that was approved in 10th of December of 1948. Because of that, this day is the day of international human rights protection. So this year we can every day commemorate and have some this kind of meetings to commemorate the importance of having human rights protection. But specifically about this Universal Declaration, what can we say? This declaration was written by two persons, a man and a woman. Do you know the name of the man who has written the Universal Declaration? It was a French man, René Cassin. And do you know the name of the woman that has written the Universal Declaration? It was the wife of at that time, the dead president of the United States, Eleanor Roosevelt. That was the wife, widow at that time, of the president of the United States of America, Eleanor Roosevelt. Because of this important declaration, René Cassin, it was a very important professor, civil law professor of France, received the Nobel Prize because of his activity in favor of the recognition of human rights protection. Obviously, you know the contents of the Human Rights Declaration. We can say many things. Perhaps two perspectives are more important. The first one is to point out that that declaration was inspired in the Jewish naturalism philosophy, the idea of persons people have human rights, although those rights are not written by any law of the state. So human rights are inherent human rights of human dignity. That is the idea of jus naturalism. If you want to have a right, there is no need to write the protection of the right, because that protection, that value is inside you, inside your existence as human being, that must be protected by the law and by the state. In this case, by the international community, obviously. And the second point is the semi-ideological subject. At that time, it was not easy to approve this kind of declaration. Remember, we at the time we were 3 years after the end of the Second World War. At the time, the world was still divided into main parties: the West countries, America and Europe, West Europe, and the Communist Party, Soviet Union at that time, and the satellite countries around in the East Europe around Soviet Union. But although this main division between two different conceptions of law and two different conceptions of human rights, although this main difference was possible to approve this Universal Declaration without any vote against the approval of this declaration. The declaration was approved only with eight, if I'm not mistaken, 8 abstentions, but no one could have the courage to vote against the Universal Declaration, because this was obvious. The content of this the Universal Declaration was with so many important rights, human rights, you can consider important now after 70 years of its approval. But at that time, this Universal Declaration was very important and very modern, because it's a very complete declaration with a very large catalogue, and also with those two dimensions of human rights, the first generation and the second generation of human rights, political and civil rights, and also economic and social rights. Obviously, at that time, we cannot speak about the third generation, because the third generation of human rights began in the 60s and 70s. At that time, those kind of problems, like environmental problems, privacy, technological, bioethics, did not exist at that time. So the third generation rights is a recent problem, not a problem that could be solved at the time of the idea of writing this Universal Declaration. From now, in the system of United Nations, because we have many systems of protecting human rights. We don't have only the universal system, that is the system of United Nations. We have some regional systems. Also in Europe, we have 2 different systems. But in the United Nations system, we have 2 main important international conventions, treaties, approved in 1966. That is the year of my birth, so it's very easy to decorate this year, 66. And at that time were approved 2 international treaties, protecting civil and political rights, and a separate treaty protecting economic and cultural rights. At that time was discussed if it would be a good idea having 2 different treaties, and why not having only one treaty putting together civil and political rights and economic and social rights. because we also speak about a feature of human rights protection that is the feature of indivisibility of human rights. But at that time, because mostly of political reasons, because of the Cold War between the West and the Soviet Union, the agreement, the possible agreement, was dividing these two kinds of human rights, political and civil in one treaty, and economic and social rights in another treaty. Because to the communist conception of human rights, that is much different from the capitalist or the democratic conception of human rights. The economic and social rights are more important than civil and political rights. So there was the need to separate these two different types of human rights in order to guarantee the approval of these two important treaties that are more detailed than what is enshrined in Universal Declaration. And mostly this treaty installed and created a procedure in order to protect the human rights. Not a court, till now is still in discussion in United Nations, the idea of having a human rights court, but the biggest countries, as you can understand, are not permitting that kind of idea or measure. But we only have the possibility to have an individual petition against the state that is violating individual human right, but there is no court. But we have before you had a committee, now you have a council, a human rights council that is more important than the committee, but in spite of that is still don't have the nature of international court, but only a nature of a body that is working together with the General Assembly of the United Nations, and not so strength as it would have if we are talking about a court, not about a legislative body or political body. From now, United Nations approved many other treaties, or proposed to the states to approve and to ratify dozens of treaties about different groups of people, protecting different groups of people, women, foreigners, refugees, children, disabled people, or treaties against negative discrimination of gender, religious or racial reasons, or it was the first phase, some treaties against and prohibiting the slavery or the genocide. So we can say that the United Nations, they are doing very well. The General Secretary, as you know, is a Portuguese guy, Engineer António Guterres, that is the Secretary General, the General Secretary of United Nations. He was a Prime Minister of Portugal, and he was 10 years the Commissioner of the Refugees in Geneva. So he's a very clever, very intelligent man, and with a lot of experience in United Nations institutions. But I think this is a good thing we can see in the United Nations, that is all the work protecting human rights. We cannot have the same conclusion in some other activities of United Nations, I must say it frankly, but I think in this field of human rights protections, perhaps the best, the most successful activity of United Nations is relating with the protection of human rights. But in the world we have regional systems. We can talk about those regional systems. The European Council system, we must not make confusion with the European Union system, because the European Council is a different organization that was created in the 50s, I think 1949, after the Second World War in Europe, only for a political cooperation reason or purpose. And in 1950, it was approved a very important instrument that was the European Convention on Human Rights. Till now, with 16 additional protocols. The most important is the protocol number 11, because this protocol transformed and extinguished the Commission of Human Rights and gave more powers to the European Court of Human Rights. What is the thing we can say, as we are Europeans? I think I can say it. Why the European Council system is a very good system, much better than the European system or the African or American system, because we are original in two things. In this system, we were the first part of the world to create a protection of human rights with the international court, not with a political body or a legislative body. The very first international court of human rights was this international court in Strasbourg. And a second feature, very important, that is this system, the European Council system, was the first system in the world admitting individual petitions against the states. So, as we are European citizens, we must be proud of our history, and in this specific topic that in the world, we were the first to create international court on human rights, and we were the first to create individual system of receiving complaints from the citizens against the states. And nowadays, this court, in many cases, can approve sanctions, civil sanctions against the states that are not respecting the human rights of citizens. A second system, this is still a regional system, that is American one. In the American continent, after the Second World War, was created a regional organization, that is the American States Organization, founded in 1948. And in 1969, this organization approved an American Charter of Human Rights, with almost the same rights we have in European system, with American Court of Human Rights also receiving individual complaints by the citizens of these states. Then we also have in Africa a system. More recently, Africa, the continent, has its own political and economic organization, that is the African Union, succeeding with the first one, that was the African Unity Organization, that was founded in 1965. And in 1981, this organization approved a charter on human rights of individuals and from the peoples of those and of this continent. There are some differences between the catalog of this charter, because in some cases this charter recognizes the rights of local people, of groups, because as you know, in Africa there are some differences of civilization comparing with the way of life of Europe or even in America. And the most important thing in Africa, I lived several years in Mozambique and Angola, that is the theme, the issue of communities, local communities, customary law of local communities, ethnical issues, that a European citizen cannot understand. Till now, it's difficult for me to understand why people feel vinculated to a customary law, but is indeed a specific reality of Africa, and this African Charter of Human Rights in some dispositions recognizes the importance of these local rights of local and ethnical communities. As you see, you have some specific regional courts. You have also some regional courts in Africa, because in Africa there is not only African Union, you also have some regional organizations. One in the south of Africa, that is ACADC, Southern Africa Organization, and we also have some organizations in the gathering the countries, the Francophone countries in the West Africa. Because I arrived yesterday from Guinea-Bissau. Precisely this country belongs to an organization, a Francophone organization, although Guinea-Bissau has as official language the Portuguese, but the name is CDAO. That is I don't know if it is the name in English, but is the organization in West Africa, and they even have a currency, their own currency in these countries. So something about the European system, not European countries, but specifically the European Union countries. We still are 28, but in the next year we'll be only 27 because of United Kingdom decided, in my view, wrongly, to be out of the European Union. But obviously I must respect the decision of Britain's citizens. In the European Union, for the moment, we have a very important text instrument, that is the European Charter of Fundamental Rights, that was approved only with a political force in 2000, but after the Treaty of Lisbon, that was signed in 2007, this charter was a binding charter because of the Lisbon Treaty. Although I think 3 countries still now are not accepting the binding force of this chapter. I think this United Kingdom, obviously, and Poland and the Czech Republic, I suppose. This is a very important catalogue because it was written in the end of last century with all the new generations of human rights. So it's a very important and very complete catalogue of human rights. The protection of these human rights is liderated by the Court of Justice, that is the main court we have in European Union bodies, that is situated in Luxembourg. Finally, my last slide, my last perspective. The future of human rights. What can we say about the future of human rights? I think we must say that the future will be a happy future, I suppose, in spite of the threats we can face now because of radicalism, religious radicalism, or because of some other problems. But we can say that are some ways in the future to protect and to develop the human rights. And something in these fields, there are already some papers, some discussions, some scientific discussion, and some political job. I think the problem of the scientific research and human identity is a issue. Obviously, the issue related with the security, personal security against the terrorism, we can accept a more restriction of our privacy in order to be more secured. That is a difficult balance, but we must reach that a new balance between those values, security and liberty or privacy. We also have a new issue, mostly in the developing countries, not in our countries, the developed countries, that is the recognition of human rights to water and even air or peace. There are a lot of papers, a lot of monographies, books recognize today that we have the human right to natural resources, water or even air or natural or some other natural resources, because in some situations some international corporations, companies are raping all those resources, natural resources from poor countries. So this is a very sad situation. Now the final question. Because of these transformations, because of these huge changings we have faced in these 70 years, is there the need to have a new Universal Declaration of Human Rights? This is an important issue because some scholars are putting this answer or the question or answering yes, in order to have a new, more complete, more modern Universal Declaration of Human Rights. Till now there is no any kind of draft. I think in this year is not a good idea speaking about the new Universal Declaration, because we are commemorating the declaration we have. But obviously we must see things substantially, not in terms of form and in a formal way, and substantially in the substantial perception of the problem. Obviously, we need to enlarge and to develop human rights and to have new human rights, or in some cases to have a new balance between some human rights, like the human right to security and the human right to privacy, or the human right to freedom or liberty. In the last years, I have been working in these issues of international security law and national security and constitutional law, because indeed this is a very sad threat we have in our continent, that is the problems related with the terrorism acts, and we must be aware of the complications we are facing now in Europe, and there is no sign of reducing that kind of there is no sign that kind of activity is in a reduction. I don't think we can say that. You also have terrorism problems not only in Europe but in Africa, mostly in Nigeria. Is where one of the most important terrorist group, that is Boko Haram, has till now killed more than 10,000 people in Nigeria. Sometimes we don't know this news because these news are not putting in our European or American channels, but this is the reality of this problem of fighting and taking measures, strong measures against terrorism. So this is my reflection. I hope you could understand my Portuguese with this very best thing that is the PowerPoint, although this part of PowerPoint is in the wall. But I think we have some more time to have some questions and to talk with each other.
would like to thank Professor Dr. Jorge Bacelar Gouveia for this brilliant lecture. It really set us the historic coordinates of human rights, and it was very fulfilling. Thank you very much.
Thank you.